Our wills are 20 years old. Can you help us update them or at least give me some advice? Hi, Jim Miskell here. You have found Let's Talk Estate Planning, which is a podcast. The purposes of the podcast are education, information, and hopefully some entertainment while you learn a little bit about estate planning. What's in the podcast does not constitute legal advice. Legal advice happens when you're sitting across the table from a lawyer who you've paid to listen to you and ask questions so that they can formulate answers that really fit your situation. And that's when legal counseling is at its best. And that's when you're getting legal advice, not when you read something on Facebook or in somebody's Reddit post or something like that. It's when you are actually sitting down with an experienced attorney to get a good, solid evaluation of your situation. The podcast is not that. And so that's my disclaimer. And now let's get on to today's topic. I got this text. It was 8:30 at night. Hey, Jim, sorry to get you to talk business after business hours, but I just realized I didn't just realize it, but Becky and I, our wills are 20 years old. This is a text. Can you help us update them or at least give me some advice? And so this is my buddy, Jimmy, and known Becky and Jimmy for years and years. And they're great folks. I wish I lived right around the corner, but they actually live in a different state. What does that mean to me? That means that I'm not licensed to practice in the state that they live in. Does that mean I can't help? No, that means that I can give them some guidance so that they're prepared for that initial consultation as they go to get their estate planning updated from those wills they did 20 years ago to today. The things that have changed in their life, you might even have a guess at, and you'd probably be right. They have two fantastic kids that are now well established. They're less than a decade out of college, each of them, but they're both in great careers and self-sufficient and make fantastic decisions. When Becky and Jimmy did their planning 20 years ago, they were young parents. And they were like, oh my gosh, we got to get something in place here. And that meant that in the planning that they did, they selected family members to be guardians for the kids and to be trustees for the kids over time, should something happen to them before they became adults. Well, here we are. The kids got through high school, had fantastic college careers. Everything went the way everybody hopes it would. And even recently, to the extent that Jimmy got to retire early last year after a great career, and it's early retirement. I'm a little jealous because he gets to do a lot of fun stuff that those of us who still work don't get to do yet. So what am I going to speak with Jimmy and Becky about? Well, first is what's really important to them now. I've got some guesses that they would like a plan that is easy for the family to administrate. Should they become disabled and upon their deaths, that it'd be easy for the kids and they can pass on any assets that are left over after they've had the fun that they want to have with them. They can pass those on to the kids without a big fat hassle. I also know that both their kids at this point in time are well established, so probably do not need a lot of guardrails protecting them from themselves. But we might talk about other things like divorce protection. What if the kids get married they both got significant others that Jimmy and Becky seem really happy with, but what if they get married? Is that inheritance, are they comfortable with it being easily commingled with marital property by their kids, or do they want to keep it isolated? That's kind of one of the things we can talk about. When it comes to ease of administration, of course, and there are a few other episodes of the podcast you can check out about how a revocable living trust can fill all the functions of a will without the need to administer through the courthouse. And the quick and dirty explanation about that, if this is the first time you've sat with me for a podcast, is that when you do a will and you name your executor, that's the person that is to carry out your will, that naming of the executor there is actually a nomination. It's not an appointment. They don't have the authority to do what you've asked them to do in the will. Even if they are your spouse or your kids, they don't have the authority to do what you've directed them to do in the will until a judge signs an order actually appointing them. This has caused dismay for a lot of folks, and the idea of a living trust is a mechanism that works for you while you're alive. It's got protections if you become disabled. And when you die, your trustee, as opposed to an executor, is not merely nominated by you, they're appointed by you. And so the instructions that you've laid out, what to do with your assets after your death, can be carried out without a trip through the courthouse. It takes more effort to set up a trust now, but it doesn't actually make any work go away. What it does is it takes work that the executor would do later, and you take it on now. That appeals to a lot of folks who want to take care of the details themselves, who are very detail-oriented, want to make sure everything's done to their specification. And it also appeals to folks that want to do work now to make things easier for the family when difficulties occur, those transitions, when they become disabled or when they pass away. So that's the quick about a revocable living trust. And that's one of the things I'm going to talk to Jimmy and Becky about, is setting things up now so it's easier for the kids later. This is a golden opportunity for Jimmy because he's retired. He's got some time to do those funding tasks and setting things up now to make it easier for their two kids so they don't have to worry about it later. And like a lot of folks, they're actually in a situation where Jimmy's mom is needing a lot more help, and they live right near her. So they help with her a lot. And so that is going to inform a lot of the decisions that he makes here. One of the big changes that they'll make from the plan that they put in place 20 years ago to now is that now they've got these two crackerjack kids that they will name as their agents for power of attorney, I'm sure for healthcare, and also for the after-death roles of executor and trustee if they go with a trust. Before, the kids were too young, and now there's nobody who knows them better, who understands their values better, and could do a better job than the kids. So that really is going to be a big change, one of the biggest evolutions in the plan as they do it. Hey, Jim Miskell here. Sorry to interrupt the episode. Hope you're enjoying today's content. A lot of times when folks are thinking about this kind of thing, questions spring to mind. If you have questions, we like to do some question and answer episodes. So you can go to our website, letstalkestateplanning.com, and shoot us a message and say, hey, on the podcast, I'd like Jim to cover this on the next question and answer session. Or if it's hitting closer home, especially if you're a Georgia resident, of course, we can't give legal advice on the podcast because it's not specific for your situation. But if you got a situation that you need to handle, it's important to get that done. So letstalkestateplanning.com is how to contact the office. I'd love to talk with you about the specifics of your situation and make sure your estate plan is everything that your family should have it be. In the meantime, we're going to go back to the episode. Thanks for tuning in, and I hope to talk to you soon. When I sit and talk with people about who are good agents, you're really looking for three things. And when I say agents, that agents takes in the role of your power of attorney agent, often called an attorney in fact, sometimes just called my power of attorney, kind of loose terminology. The next is your healthcare agent, sometimes called a healthcare proxy, sometimes your attorney in fact for healthcare power of attorney, but that medical care agent, that's the next one. And then for your trustee and your executor. You'll hear those referred to as personal representatives or agents. That's a generic term that sort of takes it all in. And when I talk with people about who make good candidates for that, I really have a three-part test that I recommend people go through. And the first is, are they trustworthy? If you don't trust them, take them off the list. They're not a good candidate. And full stop. I don't care if they're your firstborn. I don't care if your sister thinks she should do it and it really hurt her feelings. If you can't trust them to carry out your wishes for whatever reason, and sometimes people being untrustworthy doesn't mean that they have bad intent. It just means that they're not going to be able to carry through with it. So if you've got somebody that just cannot do the job, take them off the list. And it may be because they have bad intent, but they're probably not on your list anyway. But anyway, so trustworthy. You can trust them to get the job done for your benefit, acting in your stead and for your behalf. 2, some basic ability to do whatever it is that you're asking them to do. If it's power of attorney, you're looking at legal financial authority. That's the same for executors and the same for trustees. As a general description, those roles, although they cover a similar patch of ground, the authority for your agent comes from those different documents, whether it's a power of attorney or a will or a trust. So that's the second thing, is some ability to do it. And a lot of people that are good for those legal and financial authorities, for those roles, sometimes they're not the best candidates for the healthcare directives or the healthcare roles rather, and vice versa. Some folks that may be terrific with healthcare, maybe they're lousy with money. People who are great with money, maybe they get queasy and upset in the hospital. They're very emotional and shouldn't be involved in those sorts of decisions. So you need a steady hand no matter what the task is. You're looking for some basic level of ability to do what the thing is. That's where the third prong comes in of this evaluation. First, trustworthy. Second, some ability to do the task that you're setting before them. And third, and this may be as important as the second, the willingness, a demonstrated willingness to ask for help if they need it. I say it all the time. Your power of attorney agent doesn't suddenly have to be Warren Buffett smart with finances just because you get in a car accident. The beautiful thing about this agency role that you're assigning to these folks is that they have all the abilities that you do to call your financial attorney, to call the tax planner, the tax preparer, the CPA, to call an attorney, to walk them through any of the things they have questions about. So that's why the third piece is really important. If they get over their head that they're going to raise their hand and ask for help. In that case, with Jimmy and Becky at this point in time, they're going to choose each other as their first agents for everything because they're both sharp and on the ball, and they don't have any diminished capacity at this point in time. They're going to choose their kids in some order to follow up. And then there may be a niece or a nephew or a sibling as another backup somewhere down the list. I'm going to tell them what I tell everybody is don't be shy about picking backups. Nobody's ever sorry they named too many backups. When folks are sorry, it's that they've run out of names in their plan. And when the plan, even a great plan, when a plan runs out of names, that's where very often somebody is in front of a judge asking the judge to appoint somebody to fill that role. Judges are doing the level best they can, but they don't know you. They don't know your values. They don't know that your brother-in-law, Bob, is kind of an idiot with money. He's a nice guy, but they don't know that, so they may appoint him. So coming up with a list of agents of your own to your preference is a really important part of making the plan. The next thing I'm going to talk to Jimmy and Becky about is that difference between a living trust and a will plan that I sort of already reviewed. My guess is the living trust is going to be beginning to end, as it is for many families, beginning to end a living trust is often less expensive than a will plan because it doesn't have that probate component in it that a will plan does, that a will plan necessitates. And I'll work through it with Jimmy and Becky. I have really smart people say to me all the time, well, with a will, that keeps us out of probate, right? No. With a will, you're going to probate. That's the whole idea, is that the will actually needs the judge to go ahead and press activate, engage. Your agent has the authority. That's the way they work. And so I'll walk them through that and talk about the advantages versus the disadvantages. When folks are younger and they've got kids, like 20 years ago, if I was sitting down with Becky and Jimmy at the stage they were 20 years ago, we would have talked about who are appropriate agents on behalf of the kids. This gets to that second level of planning. This is what happens to your stuff after you die, or if you're disabled, how do you want things to go? And for folks with younger kids, you've got two tasks, and one is guardianship of the kids. Who do you want nurturing and raising the kids? And the other, very often, for folks that are lucky enough to have assets, who's going to manage the assets for the kids? Those two roles can be filled by the same person, the guardian and the trustee. The guardian and the conservator for the funds can be the same person. Sometimes the right person to be guardian is not the right person to be trustee. That's the beautiful thing about estate planning. As estate planning, you can separate benefit from decision making, so that somebody that deserves benefit may not have the experience or the wherewithal to make good decisions about that particular thing. You can put somebody in charge that does. And so when I work with folks that have young kids, we talk about those two roles as separate. Very often, they choose the same person to both nurture and raise the children and also to manage the money for the kids. And very often, I've got families that don't because they recognize that there's a difference in those two skill sets. Again, the same evaluation takes place, but what we're talking about here are roles to be filled during what would be called testamentary trust planning. Testamentary trust, different than living trust. You can tell because it's got a different name. Living trust, you build it while you're alive. Testamentary, that means I'm dead. And so these are the rules, the guidelines, the guardrails that I might want to put upon distributions that I make once I've passed away for the people who are receiving gifts. And again, you can separate that benefit from decision making. But that quickly is the conversation I'm going to have with Jimmy and Becky, and I don't mind them reaching out to me a bit. I'm delighted to be able to help friends of mine with the kind of thing I do every day. And that's why I enjoy the practice I've got, because I get to sit down with people who care about their family and help them figure out what's the best way to design this thing so the family gets through those tough times and can concentrate on supporting each other rather than getting tied up in administrative tasks that take them out of that role. If some of the things we've touched on today remind you of what's going on in your family or somebody you know, and you want to have a consultation, if you're in Georgia, call my office. It's the same as the podcast. Let's talk estateplanning.com. I'd be happy to meet with you, or you can meet with one of my other attorneys and get your planning up to speed. That's really when it happens, is when attorneys get to say, well, it depends. And then they get to say the second part of that answer is, let me ask you some questions so that I can give you a better answer. This has been Let's Talk Estate Planning, the podcast dedicated to the proposition that when families have estate planning in order, things go easier in times of grief and crisis. It doesn't make those times easy, but it can keep them from being harder than they have to be. My name's Jim Miskell. I've been practicing law in the state of Georgia for 30 years, and it is my pleasure to talk about estate planning because I feel like it really makes a difference in families' lives. I'll look forward to seeing you on upcoming episodes. If you have any questions or topics you'd like us to cover, throw it in the comments and we'll put them in the hat. Maybe we can get an episode out on that. In the meantime, take care of yourselves, and I look forward to seeing you next time. Thanks.